Hi, everybody, and we're going to be covering a famous landmark case called Atkins v. Virginia. Atkins v. Virginia is not focused on juveniles, but it is very important to another juvenile case that we're going to be talking about in the very near future. So it's important for you to understand this case as background context. So Daryl Atkins and a guy named William Jones captured and robbed a man named Eric Nesbitt, and these are all adults. These are all adult crimes. After driving Nesbitt to an ATM and demanding that he remove money, at gunpoint, the two shot and killed the victim. Subsequent to their arrest, both Atkins and Jones were charged with capital murder, armed robbery, and abduction. However, Atkins was evaluated because he didn't seem to be of an average or regular level of intelligence. And after he was evaluated, it was determined that his IQ was a 59, which is very, very, very low. Low enough, in fact, that it constitutes a cognitive disability. So ultimately, and just for some context, the average IQ is about 100. So that's pretty far below the average. Atkins was, regardless of his IQ, was convicted on all charges, and he was sentenced to death. In response, Atkins and his attorney appealed to the Supreme Court and argued that performing a execution sentence, a death sentence, on somebody who is not mentally culpable because their IQ is so low that they can't make decisions like the rest of us. They can't weigh costs and benefits like people with an average or above average IQ to make a determination about whether they should or should not engage in certain kinds of behavior. They simply can't do that. They don't have the same IQ that the rest of us are working with. And therefore, is applying a death sentence to someone for their level of decision making when it is their decision making is limited, is it constitutional? Is it a violation of the Eighth Amendment prohibition against cruel and unusual punishment? And ultimately, the Supreme Court said, yes, it is a violation. It is cruel and unusual to execute somebody for a crime they committed when they can't make the same kinds of decisions as the rest of us. They do not have the cognitive function as the average human being or the above average human being. Therefore, we're not saying that they shouldn't be punished for their crime. We're not saying they shouldn't be incapacitated because they're not dangerous. Of course they're dangerous. He's proven that he's dangerous. But is it fair to execute him? And the court said ultimately, yeah, this is not fair. This violates the Eighth Amendment cruel and unusual punishment doctrine because literally retribution and deterrence don't carry the same weight or value with somebody who is functioning at such a low level of IQ. They can't weigh those costs against those benefits and make a decision. So ultimately, under this theory, imposing, excuse me, imposing the death penalty against somebody who has cognitive disabilities does not merit punishment. And ultimately, they can't make that decision-making process that is required of deterrence, and therefore the execution sentence is cruel and unusual. And therefore, Atkins' sentence was commuted from a death sentence to a life sentence.